Good morning. My name is Terry Leone of Leone Law. I'm a member of the Contra Costa County Bar Association Board of Directors, and I'm also the Solo Small Firm Section Liaison. I'm so pleased to welcome you to the 27th Annual MCLE Spectacular. I hope you are all feeling updated, up-leveled, and uplifted. I'm also honored to introduce this part of the spectacular presented by the Solo and Small Firm section. 5 best practices for operating a solo or small law firm post-pandemic. Now, I'd like to introduce our sponsor for this program, the cloud-based law practice management software company, Clio. Rio Peterson, the Affinity Partnership Manager for Clio, would like to say a few words on behalf of our sponsor. Rio, take it away.
Awesome. Thank you so much, Terry. It's wonderful to be here. Hello, everyone. My name is Rio. I'm also known as Rio from Clio, and Clio is really excited to be sponsoring this year's MCLE Spectacular. So if you haven't heard of us, we are the world leader in legal practice management software, and we have products that help you manage everything from intake to invoicing. So Clio Manage is our practice management solution, which helps you keep track of your clients, your matters, your tasks, your calendar, all of those things that are really essential to running your practice. We also have Clio Grow, which is our legal intake software. It helps you build a streamlined intake process so that you never miss an opportunity to bring a new client on board. Now, Clio is also a proud member benefit of the Contra Costa County Bar. And so if you are new to Clio or an existing Clio customer, you qualify for a discount on all of our products. If you would like to claim your discount as a new customer, you can visit clio.com/CCCbar. Or if you're an existing customer, you can email me, rio.peterson@clio.com, and I will apply your discount for you. Thank you so much, everybody. And Terry, I will send it back to you.
Great. Thank you so much for all that information about Clio. Rio from Clio. I love that. So great to remember you. And for your sponsorship of this event, we thank you for it. We appreciate it. And thank you for your continued support of the CCCBA. Our event and program sponsors like you, Clio, are such an important part of our CCCBA community. They make it possible for us to provide events like this. So members, please support us by supporting them. And one of the things you can do is during this event is to go to the virtual sponsor booths on the Spectacular site. So please be sure to visit Clio and Rio from Clio. So before we begin the program, I'd like to remind everyone of just a few things. So first, for assistance with technical difficulties, go to the FAQ tab on the event's main page. Second, although the program is pre-recorded, the speakers are available live in the chat to answer questions during this presentation. They will also be available in the live Q&A immediately following the presentation. So now on to the main event. I will pass the microphone on to Heidi Coad-Hermelin, the co-chair of the Solo and Small Firm section, who will introduce today's speakers, and she's also speaking herself. So Heidi, take it away.
Thank you, Terry. It's a pleasure to be here. So today, as Terry mentioned, we're going to present 5 practices that hopefully will be helpful to you. And I'm going to tell you what those 5 are now. So we are going to be talking about client and matter selection and retention. We are going to then talk about case management and calendaring. Next, billing and trust issues. Then document management. And finally, ethical issues in the electronic cyber world. So a bit about myself. As Terry mentioned, I'm co-leader of the Solo and Small Firm section along with Anina Dawson. I have been an attorney for 29 years, mostly practicing litigation in small firms. Since 2009, I have been in partnership with my spouse at the Hermelin Law Firm, and we practice in real estate, business, and bankruptcy. Now I'd like to introduce our 2 speakers, and the first one is Diane Camacho. She is the founder of DLC Consulting Services, LLC. She has spent more than 25 years as a legal manager in San Francisco for firms of various sizes. For the past 5 years, she has consulted to small firms around the country on a multitude of management and operational issues. She speaks in the legal community on issues such as diversity, legal practice management software, and legal staffing. In addition, she teaches law office management at the San Francisco State University. Diane is a certified legal manager and holds a degree in organizational behavior and leadership from the University of San Francisco. Our next speaker is Don Davidson. He's a trial lawyer with over 35 years of experience as an assistant DA in Manhattan, as a federal prosecutor, as a deputy GC at UBS, and as a partner with multinational law firms in New York and San Francisco. Don Davidson recently launched his own firm in Walnut Creek and defends white-collar criminal cases and financial professionals who find themselves under investigation by the SEC, FINRA, and other regulators. So next, we'll turn to our first topic of client and matter selection, and we'll hear from Don.
Morning, folks. Nice to see you virtually. As Heidi mentioned, I've been around the block a few times, but I share probably one characteristic with some of you, and that is that I'm relatively new in my current job, which is a solo small firm owner. And it's interesting to be making that transition after having been in big law for close to 20 years and having all the resources that I had and no longer have. But one of the first topic we're going to talk about is client and matter selection, which is can be critical, particularly if you're trying to make sure that you're operating both in a financially successful and viable way, but also ethically and keeping out of trouble with bar and malpractice folks. So the first question you probably want to ask yourself is, can I take this particular matter on? And there are a few components to that. The first and most obvious one is, are you admitted in the relevant jurisdiction, and if the matter involves litigation, before the relevant court? If not, can you apply to proceed pro hoc vice? And if so, is the additional expense to the client to engage local counsel justified, and have you discussed that with the client? That's important. You don't want to get into a pro hoc application, find out you need local counsel, and then turn around and tell your client, oh, by the way, you're going to have to hire a second lawyer in the jurisdiction where we're going to be having this case. Second issue you got to think about, and it's an obvious one, but nevertheless, we need to discuss it, is, are there any conflicts of interest that would prevent me from representing the prospective client with the necessary zeal and duty of loyalty that you owe that client? Anyone that's made it through the MPRE, of course, knows that a lawyer can't take a matter that is directly adverse to an existing or former client if the lawyer is currently representing or has represented that client in the same or a substantially related matter, and or if the lawyer has been exposed to confidential client information of the potentially adverse client. But just because there's no obvious conflict doesn't mean that there are no potential conflict issues that you need to think about. Rule of Professional Conduct 1.7a provides that a lawyer cannot, without informed consent from each affected client, represent a client if there is a significant risk that the lawyer's representation of the client will be materially limited by the lawyer's responsibilities to or relationships with another client, a former client, or a third party. This is somewhat broader than just, am I already representing an adverse party in the same or related matter? And you have to think through those issues. For what there is a ethics hotline you're probably all aware of. They probably won't give you specific advice on, legal advice on, can I take this client or not? In fact, you can bet your life they won't. But nevertheless, if you want to talk through with somebody, that's not a bad resource to call. They do answer the phone pretty quickly and can be very helpful, and at least point you to the right rules and the right ethics opinions if you're struggling to come up with an answer. So an example of something where, even though you're not already representing the adverse party in another matter, you could still, for example, be representing a corporate entity and are then asked to take a matter adverse to an affiliated company, a member of the same corporate family. Even though it's a separate entity and therefore not the same client, the same legal client, the corporate relationship may be too entangled for you to handle the new matter effectively. So that's something you have to think about. The third issue is competence. And this is a big one. The first two are kind of obvious. Are you admitted and are there any conflicts of interest? This one's tricky, and it's tricky because the temptation is out there, particularly as a solo or small firm, to take in something that looks like it could be a good paying matter, a new client, could be a great relationship, and could be paying your mortgage and your office rent for the next year. So it can be very tempting to get out over your skis and maybe get into an area where you don't have the necessary expertise, subject matter knowledge, or skill. Lawyers I know who both prosecute and defend legal malpractice cases have told me that the single biggest mistake they see lawyers make that leads to malpractice claims is taking on things outside your area of expertise, getting outside your swim lane. Now, that doesn't mean that you can never take on a new matter or get into a new subject area. It's not as if you're limited to whatever you happen to know when you start your practice. You can branch out. But if you do so, be aware of Rule of Professional Conduct 1C, which says that if a lawyer does not have sufficient learning and skill when the legal services are undertaken, the lawyer nevertheless may provide competent representation by associating with, or, where appropriate, professionally consulting another lawyer whom the lawyer reasonably believes to be competent, or 2, acquiring sufficient learning and skill before the performance is required, or 3, referring the matter to another lawyer whom the lawyer reasonably believes to be competent. So with a nod to the robot in Lost in Space, the message here is danger, Will Robinson, danger. If you're going to do it, go in with your eyes open and make sure that you've covered yourself and that you can later on explain, if you had to, why you thought you could take on a particular matter, even though you hadn't handled a matter like that before. You need to be able to document and show the steps you took to become competent, to become knowledgeable. The fourth consideration here, and this is sort of cousin to the competence issue, is do you have the time and resources to handle the matter competently? You might have the knowledge, you might have the skill, you might have the subject matter expertise, but do you have the time and the resources? Or put another way, what happens when the dog finally catches up to the bus? If you're a solo small firm, a lawyer, and you're thinking about taking on a matter that might be well within your wheelhouse, but you're going up against a large corporation defended by a mega firm that's going to throw all kinds of resources at it and is going to brief you and motion you to death, do you have the ability to swim with those sharks? And you have to really ask yourself that hard question. Or if you can't, is there a way you can supplement your efforts, supplement your resources, take on another lawyer perhaps on a contract basis if you need to, pair up with another lawyer who's in that same area? It can work the case with you. Biting off more than you can chew is a recipe for a pig's breakfast. So there's some significant concerns to weigh. Do you have the time and bandwidth to competently handle the matter? Do you have the necessary resources and support? And if you don't, can you acquire them? Have you been forthright with the client about any outside help or resources you're going to need? Surprise is your worst enemy. You don't want to get into the case and then turn around and have to tell the client, oh, by the way, we're going to need to hire a couple of paralegals and some associate attorneys, and that's going to cost some more money than what we talked about earlier. So the next question is, so we talked about, can I take this matter? And we've gone through the relevant considerations there. The next big topic is, should I take this matter? Just because you can doesn't mean you should. Does anything, and then you want to ask yourself a few questions here. First, is there anything about this engagement or this client that sets my spidey senses tingling? There's some yellow flags that you might want to be paying attention to when the client walks in the door or when that phone rings. For example, does this client seem like they're going to be difficult? Are they going to be a handful? And if so, are you willing to put up with that? And can you see down the road that there's no problem here on the path to successfully representing this client? Another yellow flag is, has the client had serial attorneys? Are you the third attorney that the client is bringing in to handle the matter, or the fourth, the fifth? If so, that's a flashing yellow light. There shouldn't be any reason why a client who's being reasonable and has a good case, or at least a defensible case, is coming to you as the third attorney after having one and two before you. That's a big yellow flag. Another warning sign is the client what the British call economical with the facts, or squirrely, not telling you things, not answering your questions directly, changing the subject. Those are all warning signs too, particularly if they can be case dispositive. You need to know that stuff up front. Just because there's some hair on the dog doesn't mean you don't take the case, but you want to know what that is before you wade in there. And if the client's not sharing that with you, that's not the start of a good attorney-client relationship. Another yellow flag is, does the client seem to want to go tilting at windmills? Now, all clients particularly individuals, become heavily invested in their matter. they convinced they've been wronged and they want justice and they want to go full bore and take it to the other side. That's natural. It's human nature. But then there's the client who, is convinced that there's no other side of the story but hers or his, that there cannot be any possible question but that they win. And when can we get there? That client is what I call someone who wants to tilt at windmills. And I stay away from clients like that because there's no outcome of that case, or very few outcomes of that case that are going to make that client happy. And at the end, you're going to end up with an unhappy client and possibly a fight over your fees, possibly even a malpractice suit when the client says you promised something that you didn't deliver or you didn't disclose something to the client, et cetera. The next question you ask yourself about, do you want to take the matter, is, do I know enough about the client to want to be tethered to him or her for the balance of this case? You want to do your homework. Google the client, check social media, Facebook, LinkedIn, et cetera. If the client's a company, take a look at their available public filings, Better Business Bureau, Dun & Bradstreet, and it's also worth checking dockets for litigation history. Is this a professional litigant, someone who's always getting sued or suing somebody else? That's somebody you may or may not want to represent. Maybe you think it's a client who ends up suing a lot of folks, but they pay their lawyers and they're big boys or big girls and they know the risk of litigation. Fine. But some of those clients are serial litigators, and that can be bad news. Then the next.
Can I break in for a moment here?
Sure, go ahead.
I think another way to have a happy practice is to check out the opposing party and the opposing attorney as well before you decide to take them on the defense. You'll know who the plaintiff's attorney is, and you know their reputation, or maybe you do all those searches for them as well to see, is this case going to keep me up at night, keep me working on the weekends, based upon who those people are.
Yeah, fair point. Yeah, if you know you've got a docket of other cases, you may not want to take a case where the other side is represented by some, burn the walls down, leave no stone unturned litigant who's going to really run the costs up and run your time up. The next question you might want to ask yourself is, will taking this matter prevent me from taking on other matters in the future that might be more lucrative or beneficial? Getting married is easy, but getting divorced is tougher. And you want to consider any potential future conflicts. And in addition to the legal conflicts, consider possible business conflicts. For example, when I worked at UBS, we hired lots of lawyers. Lawyers we never hired were lawyers who sued the securities industry. And it wasn't just us. The securities industry is very parochial about that. They figure you're either with us or against us. And if you're against us, we ain't hiring you. And it doesn't matter that you didn't sue us, that you sued Goldman or Merrill Lynch. We're not going to hire you if you're litigating against the industry. And that could be true in other industries as well. If you're taking on a products liability case against Ford, you're looking for work later on from General Motors, you may not get that work for the same sort of parochial concern. So that's the sort of the initial consultation issues and the initial things you want to think about when you get in. I was going to move to the initial discussion with the client, Heidi, unless you have other topics you want to talk about.
Nope, I think, go ahead.
Okay. So I always make sure, the question here is, who's the client? If it's a sophisticated institutional client and you're dealing with in-house legal counsel that's been around for a while, you're going to skip a lot of what I'm about to tell you because, frankly, it would be an insult to their intelligence to go over. But I'm going to assume that you're dealing with a less sophisticated client, possibly an individual, possibly someone who's never been in litigation before, or if they have, it's not been the kind of litigation that you're talking about now, or the legal matter you're talking about now. So I always go through kind of a here's how this is going to work discussion with them so that they know what to expect. As I say, surprise is your worst enemy. The first thing is strategy and timetable. Strategy, have one. What's the strategy for this matter or this case going to be, and what's the path to success? How are you going to get there? And what are the potential obstacles on that path? All of that should be discussed up front with the client because, again, you don't want to get halfway down the runway and then the client says, oh, I didn't know we were going to, they might move to dismiss, or I didn't know we were going to have to do all this discovery stuff. Why is this costing so much money? I thought we'd be done by now. We filed this case 6 months ago. So you got to talk about strategy. You got to talk about the timetable. Most clients, highly underestimate both the cost and the amount of time that a matter is going to take, particularly in litigation. Transactional, which I don't do, but I know transactional lawyers, is a bit easier to predict. But certainly in litigation, you have to prepare the client for the inevitable bumps in the road and for what is going to likely be a fairly long journey that they're going on. You want to make sure that you've discussed the potential fees and what it's going to cost and what the exit ramps to the case are. You also want to have a fulsome discussion with the client, particularly a new or inexperienced client, about the attorney-client privilege. You want to warn them about things like using work email, which can waive the privilege because work email can be accessed by the client's employer. And if that happens and it's done by the client knowingly, then he or she could be waiving the privilege as to your communications with the client. The first thing I always tell them is use your personal email address with me. I also tell them, make sure you put in the subject line privileged and confidential of every single email you send me. And I do the same thing when I send it to them. In case there's ever a privilege review of their email, it makes it a lot easier to find privileged emails if you've properly labeled them than if somebody has to go fishing through and finding out, is this attorney-client communication? You want to warn them about sharing the contents of privileged communications with others. You want to warn them about having privileged conversations in public places where they may be overheard by others. And you want to warn them about posting privileged content on social media. That didn't used to be a big deal. Now it is. Somebody's in a case and they're going to post something on Facebook about how their case is going, and my lawyer said this and my lawyer said that, and it's looking good. And all that stuff, depending upon how it's done, can constitute a waiver of the privilege. The other thing I warn them about is document retention. And again, this is for new clients, even more experienced clients. You have an ethical duty, certainly under the federal rules, to warn the client that they've got to retain any relevant documents, and they have to institute what's called a litigation hold and send that litigation hold to anybody within the entity, within the company, who might have relevant information. If the company has a regular purging process or destruction process, and many do because it's expensive to keep both hard copy and electronic data, so a lot of companies will get rid of stuff, and some of them have very quick triggers. You got to warn them upfront and fast, because you don't want to be standing in front of a judge 12 months down the road defending a motion to compel or a motion for sanctions because your client failed to retain, you didn't stop their normal email destruction policy, and now relevant email has been lost. And then the judge is going to say to you, well, Mr. Davidson, did you tell your client he or she had to put in a litigation hold in effect? It's a tricky question to answer because now you're getting into privilege issues, but you certainly don't want to be having to go back to the client and say, yeah, I should have done that. That has to happen up front. So that's the end of this first section. Heidi, if there's questions, I'm happy to interact with you on those. Otherwise, I think we can move on.
I think you're right. We're going to next move on to case management calendaring with Diane.
Thank you. Hello. So I'm going to get into more of the operational pieces of the managing of your cases. So when you've gone through your onboarding and you decided that you're going to take a client, one of the things that you want to make sure you do, and some small firms don't always do this, is you really do need to do some sort of conflicts check formally. And formally could be an email to everybody in the firm asking them if they know of any conflicts and saving that and keeping that record with your engagement agreement. That's one of the things that your professional liability insurance is going to ask you about, what your policy is and how you keep them. And it's also something that you can often run with your practice management software. And Dawn mentioned the different things that you should be checking for as far as conflicts and the different type of information you should be putting into your system so that you can run an effective conflict check going forward. So you definitely want to do that. Run it, save it, keep it in a place you can retrieve it if you're asked about it. And you also want to make sure that you're using an engagement agreement and that you're getting the engagement agreement back signed. And again, these are some of the things that are just annoyances and that you just want to get in there and you just want to practice law. But these are the things that can come back and bite you later if you don't take care of them. One of them is make sure you get your engagement agreement back couple of different things that have come into play that I've seen in the recent years with engagement agreements that are a little bit newer. And Heidi's added to the handouts some optional clauses from the state bar for engagement letters, so you can get some language for these. But a couple of different things. One is when we talk about the electronic communication, we as law firms and as people that work with law firms understand that it's important that we encrypt emails, that we have a place to exchange information if it's an estate planning practice and you're getting people's banking information and their personal information. You don't just email that back and forth. We have some way of sending it securely or have some kind of portal that we can save and exchange that information. However, your client may not. And you need to make sure that your client is aware that if something is disclosed because of the way they've handled it, that's on them. That's not on the firm. And you need to make sure that that's outlined in your engagement agreement, that you're going to use these different ways of communicating. We are going to secure your data, and we're going to use our portal on our practice management software. We're going to make that available to you to send information to us and vice versa. And make them aware of the fact that they should be using that. They should not be emailing, attaching information to an email that's confidential, that's private, that has any of the other normal restrictions. So make sure that is added to your engagement agreement. The other thing that's come up lately is there's a way now to, when you're working at flat fee, when you get in your money in on a flat fee, even if it's over $1,000, you can put that flat fee into your operating bank account. However, in order to do that, you need to let the client know in your engagement agreement very specifically that you are going to do that, and that they, as the client, can say, no, I want you to put it in the trust account. So you can put it in your operating, but the client has to know, and the client has to approve of that. So it's not just something that we do willy-nilly, and it's something that needs to be very clear, again, in your engagement agreement. Your engagement agreements really have to outline what you're doing with their money and how you're handling their information, as well as how much you're going to bill and all of that kind of thing. So you want to make sure that those are updated and looked at periodically. And you may want to look at the optional clauses, just scan through those and see what else might be in there. It's also important to, and again, this is something that we do in a hurry and we may not finish, is when you're using a practice management software and you're opening up a client or you're adding a contact, add all the information. Have your assistant or someone add all the information. Again, that's for your conflicts checks. That's when you send out your bills at the end of the month that you have the email that you need to send them to. Don't just enter the information and then, oh, I'll fix that later, or I'll fill that in later. It really behooves you to take the extra 30 seconds to complete everything. And looking at your practice management software or your client intake software and making sure that you do have information there that's helpful for you managing your firm. A lot of times we're keeping spreadsheets over here about maybe who our referral sources are or how much this client is worth. All those kinds of things. That is what your practice management software is for. And you can create special fields in all of them that allow you to enter this information and keep it all in one place. So good practices when you're taking in a client and completing all your information is also very important. Calendaring is something that I find interesting for small firms. And calendaring, when I'm talking about calendaring, I'm talking about docketing. So when you're working in an IP practice, there's special docketing software for IP practices, and they normally know that, and they normally take care of that. However, if you're a small firm and you're one or two attorneys and you're calculating your dates on your calendar and you're counting and you're worried about, was the 18th, was October 12th a federal holiday? Was it a state holiday? And you're counting dates. Remember, you used to pull those blue books out and kind of look at what the dates are. There are very inexpensive docketing or calendaring programs that you now can add to your Outlook or your practice management software. Nobody should be counting dates anymore. It used to be there were no software programs for small firms, but now there are. Another handout that we've provided is a list of just various software that's available for small firms. Take a look at that. There are some different docketing or calendaring programs. It's really important to make sure that those dates are right. And it's really important to make sure that you get the right notification. So I always advise that you create a calendar, firm calendar. All the calendar dates go in there that are client trigger dates, however you want it, closing dates, whatever you want to put in there. And then from that calendar, the people that are affected, the people that have to show up, the paralegals that have to prepare, those people are added to that event, and then it goes to their calendar. So you have one firm calendar. So if somebody's out sick, somebody gets COVID, whatever, you have a calendar and you know what's going on for your firm. And then every week you print out what's due the next week. Maybe some people like it looking at it for a month, but you want to have advance warning about what's coming up the next month. And this again is or the next week, this again is a lot of times not something that's done. But if you have a calendar that only has your trigger dates, your deadlines, if you will, it doesn't matter if it's litigation or if it's transactional or whatever, and you can look at that clearly without any of your other information, you just know what's due these days, that's going to be really helpful for you and very effective for you to look at maybe on Friday afternoon. So you can spend the weekend doing something you forgot about perhaps. So those are things that are important to do. Make sure that when you're using these programs, that you give yourself a warning, maybe a 1 week warning, 2 week warning. Some people program kind of trigger dates that aren't the actual date. So maybe they say, if it's a motion for summary judgment, I always calendar that for the week before it's actually due because it's so much work and I want to make sure I have plenty of time to complete it and then proof it and make sure that the table is right and all of those kinds of things. So whatever works for you, but make sure that you're using those and take advantage of the software and of the tools that are available to you now. Nobody should be calendaring by counting. I think that we can move on to IALTA and trust, or did you have?
I wanted to add something about calendaring.
Please.
So the world's changed a lot in the last, 18 months now, and that also includes service in the state courts. So CCP 1010.6 outlines electronic service of documents. And in the past, you had to consent to it in writing before someone could serve you, but with a motion or discovery demands or so forth, electronically rather than by mail. But when COVID hit, some of the counties changed that and made it mandatory. So currently still, Alameda County, you have to accept service electronically, which is a whole nother world and a whole nother set of problems if you're not checking your email regularly. And you can designate to the law firm who gets the email. So you can designate yourself and your assistant if you have one, or your partner, et cetera. So you have some safeties there to make sure it's seen. But it's also a very interesting calculation under the CCP 1010.6 about when you get that email and on what day, when do you start counting. So I just wanted to put that out there. It's kind of a trap potentially in this age. And I don't know what's going to be in the future, but whatever county you're practicing in, I would look at their emergency rules to make sure what is the current status.
And Heidi, on the federal side, most people would know you must use electronic filing and service, the ECF system. I say must, it's actually quite convenient, but there's a learning curve and you got to get used to it. And you got to, if you're filing something, you got to spend the time, give yourself enough advance time to allow for the screw ups that are going to inevitably happen if you haven't done it before. But you must use it, and once you get used to it, it's very convenient because you can file something at 11:59 p.m. on the day it's due, and your adversary gets served immediately via email, and you're done.
Exactly. So Diane, I think we had a few points on matter closing. Did you want to address those?
Sure, I can address those now. Thank you. Mm-hmm. So the other one little thing about the calendaring I'm going to go back to, if you do have a computerized electronic calendaring program, the companies that you're paying monthly for this are supposed to check with the courts and make sure that their rules are up to date. So you're going to want to make sure you make a call or somebody makes a call to your provider and make sure that they have this on their radar and that you're double checking those last minute things that have changed because of COVID. So you don't assume that they're checking that and they're not, or you're using that thinking that they have. So make sure that you're aware of what's happening for these. Maybe there's a judge that wants something different, or with the COVID laws and things like that. Just make sure that you're checking on those kind of special circumstances. The other area that sometimes gets lost and is really important is to close out a matter. And closing out a matter in your practice management is normally you type in close, and you want to do that obviously after you've collected all of the money that is due for you for that matter. But it also means sending something to the client and letting them know that we've completed our agreement. We've completed our duty to you on this matter. And it can be a simple, thank you, it's been a pleasure, here you go. But you don't want them to come back 18 months from now and say, well, I have a question about that settlement from 3 years ago. That's really not covered in your fee. And you want to make sure that for professional liability, you have a closed date for that matter as well. And that's a good time to say, a lot of us are doing online marketing. Would you give me a review? Things like that. But you want to make sure that you have an open date and a closed date for your matters. And that often gets kind of missed. And if you're withdrawing from a matter, you obviously need to make sure that your client knows that you're withdrawing from the matter and that is very, very clear and it's documented in your system as well.
Thank you, Diane.
The first parties.
I'm sorry about that. Thank you, Diane. Our third topic today is billing and trust issues, and we're going to hear from Diane on that one.
Okay, thanks. So I'm the operations person, as you can tell, and a lot of times I work primarily with solo and small firms and have for a very long time, and we'll come in and firms don't have a formal billing process or a formal billing timeline, if you will. If you are working in a firm where there's, 30 attorneys, the day that you have to get your pre-bills done. The day that you have to get your time in for the previous month. You should be doing this as a small firm as well. You should be saying whatever it is. If it's the first of the month, everything for the previous month has to be in. All the time and expenses have to be in. And your pre-bills get run that afternoon or the second. And then you have so many days to get those pre-bills back to the person that's doing your billing. And then you get your bills out. This is really important because the longer it takes you to create that bill and to get that bill to the client, the farther in their memory the work you did for them is. So they're going to start going, wait a minute, I don't remember having 5 phone calls in August if they don't get the bill until November. But if you give it to them in September 1st, they're going to remember, that's right, I was on the phone with them all month last month. Things like that you want to collect what you bill, collect what you work, and you need to bill it to collect it. And the farther you get from the time you do the work, the less money in statistics you're going to collect. The other thing that I see is the third quarter or the fourth quarter collections ramble for small firms. Everybody, it's October. We have to collect all of our money. Everybody give discounts so we can get the money in by the end of the year and we can get, we know how much we can do for fun. That is so, so hard for everybody involved. And it's so much pressure for you. Really keep up on those. The firms that do well are the firms that don't do pro bono work for their paying clients. When you don't bill them, they don't pay you, you're doing pro bono work. If you're billing them $100 an hour and then it's the end of the year and you say, hey, I'll take 75, you're giving them $25. It's just not good business. And it's good to stay on top of it. And the way you do that is by having a system and staying with the system and not making excuses for your clients so they don't have to pay for you. So, and then you go back to the Dawn, can they pay your bill and what's your retainer? If they can't make your retainer, then they probably aren't going to pay your bill. So that whole intake. The other thing that's come in play a lot more than it had is the credit cards, being able to take credit cards. With COVID, I think almost everybody is taking credit cards. I personally use something called LawPay. I can take a credit card, and now they've added ACH, so people can actually pay me through their bank account using LawPay. So you can set that up so that you don't take credit cards, but you do take ACH through there. But figuring out some way to take payments without people writing checks and mailing them. The one thing I do want to mention about credit cards is there have been firms I've worked with that take credit card information from their clients and they keep it so that they can bill their client every month. I highly discourage you from doing this. Not only are you and your firm and your employees holding credit card information that can be stolen or misused by somebody that needs it because for whatever reason, but you also have to report that. You get this huge report at the end of the year from the credit card gods somewhere, and you have to fill out all this information about how you store them and where you store them and what your backup is and all of this stuff. If you get your bank to do it, or you get a service like I have, you don't have to keep credit card information. You never touch it. At the end of the year, they send you something saying, do you have any credit card information? Have you saved any credit card information? And you say, no, and you send it on. So be very careful, especially now that more people are starting to take credit cards. Don't write the credit card information down. Don't do any of that. Figure it out so that the client has to put the credit card information in, and then you get paid through that way. So if we go into the trust accounting piece, which is something that's near and dear to my heart personally, because we find that inadvertently small firms aren't handling their IELTA account properly. And this is how many people get disbarred. It's not intentional. It's not that somebody's taking money from their trust account and misusing their client funds. It's that you're not handling the trust account the way the state bar mandates. And then for some reason, maybe the bank makes a mistake and your account's overdrawn. Then you have the state bar coming in and auditing you and finding out that, wow, you haven't been handling it properly. So I'm just going to go through a few key points about IELTA. One, and we know this, don't borrow money from your IELTA account. It's not your money. It's never your money. The only time it's your money is if you worked and billed the client. Then it's your money. So just having AR on your books for that client doesn't mean that you get to pull money from IELTA for that client. It has to be billed. So if you're going to pull money from a client IELTA account, you better generate a bill that day, and your client better get a bill that day and know that you're pulling money from their account. I recommend that you do this during your billing cycle. You send your bills out on the 5th, on the 10th, 5 or 10 days later, you make a pull from your trust account for all of your clients. You are supposed to allow your client an opportunity to dispute your bill before you pull money from trust. Now, all of the practice management software allows you to say, I'm going to withdraw the money from your trust account, show it on your bill that I've paid out of your trust account, and this is your balance if there's anything due. You need to, again, that needs to be put into your engagement agreement. So it's very clear that you're going to draw that money and apply it to bills as you're generating the bills. So again, be clear about that. Taking money early, taking money before it's billed, that's borrowing. And it's not legal. It's bad. That's one thing that sometimes people do and they're not aware that they're not supposed to. They think if they've worked the time, it's their money. It's billed. If you get a check and it has fees and it has awards, so you have a settlement check or something like that, that check should be deposited into your trust account. You should never deposit that money into your operating account. It should go into your trust account, and immediately you should write yourself a check, or you should transfer the money into your operating. That is your piece of that, and then write the check from trust to your client. It should happen quickly, but you shouldn't put it into your operating. That's always a question. It should go into your trust, and you should always separate it very quickly within a reasonable amount of time is kind of what the term is. But you don't want to have your money and the client's money commingled. And that's when you start putting your client's money in your operating account, or you put it in your money in the trust account, because you're just it's going to be a savings account, and you're going to kind of, no, it's not a savings account. That's your client's money. Keep your money separate. The other thing that I see is sometimes there's a lot of activity on your trust account for certain clients. So maybe you're doing a deposition. So you're paying the deposition company from a trust check, and you're doing all of these different things instead of paying for them out of operating and then billing the client for everything for that month, fees and costs, and making one withdrawal. You can do that. You can make a bunch of different withdrawals. It's messy and it's very, very difficult to reconcile. And it's not something that we recommend at all. You should make one withdrawal per client from your trust account a month at the most. And it should cover all the costs and fees for that month. Your trust account shouldn't be a way for you to manage your cash flow. So one of the things that is important is making sure that you have the proper records and the proper way to reconcile all of your trust accounts. And again, one of the handouts is the State Bar Trust Account Handbook, I think it's called, or something like that. You have to have a report for each client that has the money going in and the money going out, and a running total for each activity for the month. So if you have 15 different entries and in and out and in and out, it's just more to reconcile and to handle. You want it to be clean and neat. And if you get audited, you want it to be very easy for somebody to see that you're doing it appropriately. So 2 reports that are very important. One is you have to have a report from your time and billing software that has, for the client, how much money is in the trust account and how much money is being taken out and why, and a running balance. There's examples in the handout. The other one is for the entire firm, how much money you have in your trust account and who it is for. That is part of the 3-part reconciliation, and that is often the part that gets missed. So you have your time and billing software, and you are accounting for your trust money, and that's what your client sees. And if they want a client ledger, that's normally what you would print out and hand to them. This is the client ledger. And then over here, maybe you're using QuickBooks or Xero, and you have your bank account. So your trust account is managed. Your bookkeeper is reconciling your trust account. So they're looking at your QuickBooks trust account and balancing it with your bank. And they're saying, okay, it says here at the end of the month that you have $10,000. The bank says $10,000. So you're good. You're not. Your time and billing software also has a number at the end of the month. If that says $15,000, that's a problem. And that's the third piece of the reconciliation. Your reconciliation should be your time and billing software, your bank, and your financial software. So all of those should be the same amount at the end of the month. That you need to double check that all the time. You should get reports about that every month. And that's one of the areas that unintentionally people get in trouble.
Diane, thank you for that. We need to move on to document management.
Okay.
And we're going to hear from Diane one more time.
Okay, my last little piece, and it's a little piece. One of the things with the work from home, remote working, that we're seeing a lot of is document management. And it's harder to exchange information when you're doing it remotely than when you're doing it in the office and you're yelling out your door, Diane, where is document ABC? When you're looking at documents and you're picking them up from the airport or your house or the office or wherever, it's very important to have your client documents in a neat and orderly fashion and in one place. Not to have it on different people's computers. And sometimes people are using Box and sometimes people are using your practice management software. And sometimes, oh, they're all in my emails. I just don't ever save them. All my documents are in my emails. It's really important to have a secure location for your documents that can have them organized by whatever you want to have them organized by. Client matter is normally what it is. Sometimes it's just client because you don't have different matters. And to have it backed up, and you should be having it backed up to the cloud now. There's very, very reasonable ways to have your documents backed up to a cloud. You should be able to get those documents if something happens to your computer, like you get hacked. You should be able to get into your backup and get your documents without having a brand new server created and put together, which could take weeks to happen. So you want to make sure that your documents are retrievable. And you want to have some order to them. I've gone into law firms and it's very easy to have a very simple folder structure that you apply on every new matter. That is, you've got your correspondence, you've got your agreements, and you've got your memos. And that's what gets assigned every time you open a matter, and it's consistent. And your naming needs to be consistent so that you can find things and that there aren't random abbreviations. So you want to be organized. You don't want to go crazy. You want to not have so many folders within folders within folders within folders, because if you ever want to get out of that system and do something more electronic and do something more searchable, some document management type of true document management system, it's impossible to get your documents out of that folder string. You have to start physically handling each document to get it out of that deep folder string. So just a helpful hint in that regard. But you want to make sure that you have a reliable system and you stick to it, that all your documents are in one place, that you have a decent way to get to them from anywhere, and that you have a way to get to your backup.
Great. Thank you, Diane.
You're welcome.
Our final topic today, ethical issues in the electronic world, and we're going to hear from Don on this one.
Sure. So there are a few issues here. I suppose you could divide them into two big buckets. One is confidentiality. Obviously, as a lawyer, whether it's a litigation matter or a transactional matter, as lawyers, we have an ethical obligation to keep client matters confidential, keep client information confidential, which means taking appropriate steps to protect it when we store it, send it, et cetera, electronically. Back in the old days, it wasn't that big of a deal. You were using paper. Paper was in a locked file cabinet, in your file room, in your storage room. When the case was over, it got moved to another locked location and stored files that you paid an arm and a lung to store, and eventually you threw it out. The electronic world, completely different story, makes it much easier to retrieve documents, but it also makes it much easier for others to get into your documents. So the first issue is the confidentiality. And here you got to make sure that you know what your systems are. Is your website secure, where your document retention and also your email system? How do you know that it's secure? Do you test it regularly? at all three law firms that I was with, our IT department used to do sample targeting, where they would send us phishing emails and others to see who bit on a suspicious email. And then if you did, you were going to get, a nasty gram from the head of IT. And if you did it more than once, you were going to hear from the head of the firm, which was not a good place to be. Obviously, that's probably a bridge too far for a small firm, but there are vendors who can provide that service for you, test you, make sure that your systems are secure. Because at the end of the day, yes, you want to do what you can to make it secure and try to prevent data breaches. But if, God forbid, there is a data breach, you want to be able to show that you had a reasonable process in place to protect that client information. And that might include testing, depending upon the size of your firm, the number of employees you have, kind of matters you handle, the kind of clients you have. But you want to be able to demonstrate the steps you took to try to prevent a breach that, notwithstanding your best efforts, nevertheless occurred anyway. And, you can open read the newspaper or open the blogs every day and see about the most recent phishing targeting attack. Now, small lawyers are probably not the juiciest targets for hackers compared to, say, for example, a company that stores a lot of consumer data or health data. Target, for example, companies, as Diane was talking earlier, that store credit card information, social security numbers, et cetera. So perhaps we're not as juicy a target as a Walmart or a Target, but nevertheless, we still have to have processes in place to be able to defend what we did if we do get hacked. And that includes your email, your document management system, and your devices and your computers. Are those secure? Do you have to? Are they password protected? Is anybody still using the password for their password? Or when you walk around the office, do you see people with their passwords on Post-it notes stuck on their computers, which is obviously not the most secure system in the world? Have your staff been trained on how to avoid and not fall victim to phishing and other malicious email or internet scams? Again, kind of basic blocking and tackling, and it's not going to guarantee that you'll never be hacked or never prevent it. But if you've taken steps, if you have a system in place and you can demonstrate what that system is and what those steps were, and that you diligently followed the steps, you're going to be in a lot better place if there is, in fact, a breach. And of course, as Diane was saying, you got to back up your data. If you read all about ransomware attacks, where somebody, even though they're not actually taking your data, your data and client information, they're blocking you from accessing it. And if you're in the middle of a case and you need to get that, and the hacker's saying, "Okay, well, we'll release your data for you, but just send us $100,000 in Bitcoin," you might not have a choice. And you want to be able to say, you know what, we've got it backed up elsewhere. It's inconvenient, but we can restore the data, and we don't have to go out and pay somebody $100,000 in Bitcoin as ransom. So you want to make sure that you do have backup systems for your data, that you can access it, and that it's in a place and stored in a manner that is a backup in case you ever are hacked, that you can go and get it and not have to say, "Oh my God, what are we going to do? We're blocked from accessing all of our files." And that has happened, and it does happen to small firms.
It does. It does, Don. And we've had, 4 attorney firms, 3 attorney firms. They just spray out this information. Whoever bites, like you said.
Yeah, and some of them are reasonably sophisticated, and all it takes is one careless moment, or somebody rushing to get something done, and the email comes in, and they clicked it, and the next thing you know, where's our data? We can't get our data. Of course, if you do get hacked, or if you do have problems accessing your data to do this, you clearly have an ethical obligation to disclose that to any affected clients. You can't, sit on your hands, hope they don't notice it, hope that you can fix it before it goes away. You got to blow the whistle and say, "Hey, you don't want to hear this, but we got hacked this morning. It was a breach, and we're scrambling to figure out the extent of it. And we're going to keep you apprised." You got to be upfront with your clients if that happens to you. And the State Bar recently issued a ethics opinion that you might want to be aware of. It's 2020-203, which says that lawyers who use electronic devices containing confidential client information and computers must take reasonable steps to secure their systems and minimize the risk of unauthorized access. Well, okay, that's not the most helpful advice in the world. Obviously, not very detailed. It's sort of like, do good, avoid evil. Thank you very much, State Bar. Nevertheless, somebody will point to that down at the end of the road if they say, "Well, did you comply with this opinion letter?" Then, if you are breached, lawyers have an obligation to conduct a reasonable inquiry to determine the extent and consequences of the breach and to notify any client whose interests have a reasonable possibility of being negatively impacted by the breach, what we were talking about before. So do what you can to prevent it, show what you did to try to prevent it, and then God forbid if it happens, take the appropriate steps forthrightly and be candid, be upfront, open the kimono and say, here's what happened. We're going to fix it, and we're going to make sure that you don't get hurt by this. There's a lot more to that topic, but we are out of time, so I think we'll have to leave it there.
Thank you, Don. Thank you, Diane, for all that great information.
Sure.
And I see Anne is back.
And thank you, everyone. That was amazing. I think we have a lot to think about. I'm Ann Wolf. I'm the Education Events Director for the Bar Association, and I want to thank you all. That was great. And I know that our solo and small firm members will be very appreciative of everything you had to offer today. I also want to thank Terry Leone and Rio from Clio for their input and support earlier in the program. So right now, I'd like you all to stay tuned for a live Q&A session coming up after I make a few announcements. So the materials and evaluation forms for this program can be downloaded from this session page through the Files tab above the chat. Attendance certificates will be available after the Thanksgiving holiday. And if you are a CCCBA member, your attendance certificate will be on our website in your member profile. If you are a non-member or would like more information on how to get your attendance certificate, look for information under the FAQ tab on the main event page. Also, for assistance with any technical difficulties, head to those FAQs. They'll tell you everything you need to know. So you are now invited to join the live Q&A session with our panelists. So below the screen on which you are viewing this session is the link that will take you directly to this session's live Q&A. So now click the link and join the live Q&A session. I'll see you there.